How does Texas law handle property division in a high asset divorce?
So to start with, Texas is a community property state. And what that means is that there is a presumption in the law that every asset that is owned by either spouse is community property and therefore belongs 50% to each spouse. It is the duty of either spouse to overcome that presumption to establish separate property as part of the divorce. And if they're able to do that, then those separate property assets will be awarded to the spouse that owns them. However, with the community property, the presumption is that the division will be 50-50. However, that does not necessarily mean that at the end of the divorce, each spouse is walking away with exactly half of the value of all of the marital assets. What that means is that at the end of the divorce, Texas is going to do what they consider a just and right division of all of the marital assets in the divorce. You might have retirement assets, vehicles, residential property, real property, a ranch, you might have trailers, you might have boats, you might have all kinds of assets. And each asset individually may not be able to be divided exactly in half. So Texas is going to take the cumulative value of all of your assets and then do a just and right division, taking into consideration factors like the length of the marriage, the income and earning capacity of the spouses, the fault in the breakup of the marriage, and other external factors that come into play in any divorce situation. And once the court considers all of these factors, then a just and right division will be made, which may or may not be equal to a 50-50 division of the community assets.